want to grab a seat?
Yeah.
So good evening, everyone. My name is Owen Eagan, and I'm the West Hartford probate judge. Thank you all for coming out this evening. First snowstorm of 2025. You were very, very brave to come out. We're happy to have you here. This is being filmed on Channel 5, as all the series, all the four-part series has been filmed on Channel 5, thanks to Jen Evans and her wonderful crew that are here. So, as I said, this is the fourth part of a four-part series. And if you've missed one of the other parts, you can watch it on Channel 5. The first was the probate process. Second was estate planning basics. Third was estate taxation and the use of trusts. And tonight, you're in for a great one, conservatorships and Title 19/Medicaid. And we have some wonderful attorneys here. They're very, very skilled and excellent attorneys, and I know you're going to enjoy hearing from them. First, a disclaimer. Everything that's said this evening is not legal advice. Do not substitute what you hear this evening for talking to a lawyer. You need to talk to a lawyer if you have legal questions. Now, you can ask questions tonight, but you need to talk to a lawyer to get advice. So that's our disclaimer. So I want to thank Leah Farrell for hosting all four parts of the series. She's been wonderful. She's organized this here. And again, Jen Evans and her crew for filming. That's wonderful. If you've been to any of the other series, you know that I'm going to start off talking a little bit about the history of the probate court. And the probate court was established in Connecticut over 300 years ago. And if you think about it, I think Thomas Hooker came here in 1636. And so probate court was established by the 1700s. And the probate court, way back when, dealt with two things. They dealt with transfer of assets at death, so decedents' estates, and they dealt with people who had in need of a guardianship or who were incompetent and needed help. And there were only 4 courts then. There are 54 regional courts now. West Hartford happens to be its own region, and I happen to be the judge in that region. The judges are elected. They serve 4-year terms, and then they're reelected if they're blessed enough to be reelected. Back then there were 4 courts. One was in Hartford, one was in New Haven, one was in Fairfield, and the other one was in New London. And now, as I said, there are 54. We broke away from Hartford in 1982. That wasn't too long ago. So West Hartford broke away from Hartford in 1982. We used to be the west part of Hartford, and we did all our hearings in Hartford until 1982. First probate judge was John Berman, and he started the court in 1982. After that, it was Sid Elkin, and then I'm the third probate judge. As I said, I'm part-time. Most judges are part-time, and we have our own private practice as well. Not all judges, but most have their own practice. The jurisdiction of the probate court, we have jurisdiction that's afforded us by the legislature. So we're a creature of the statutes. We are only given power by the legislature, and we are only allowed to exercise the power which we are given. Before, when they dealt with decedents' estates and guardianships and so forth, they've since expanded that now. We deal with trusts, we deal with conservatorships, we deal with guardianships, termination of parental rights, adoptions, removal of parents as guardians, paternity matters, emancipation of minors. We deal with commitments of people with psychiatric disabilities. There is a psychiatric hospital here, the Connecticut Behavioral Health Center in West Hartford, and we deal with people who are committed and have psychiatric disabilities. We also deal with name changes, among other things. In summary, the court deals with death and its consequences, which it's always dealt with, capacity, and parenting. So it's an interesting court. The primary goal of any probate court, and our court here in West Hartford, which is located in the town hall, is to be of service to all the people that come through the doors. So if you're in the wrong court, we'll get you to the right probate court. If you filed the wrong document, our staff is extremely skilled, compassionate, kind, and they will help you with whatever matter you come in the door with. People don't understand that. I try and tell them, just walk in and hand something to a clerk and say, I've tried to do this, can you give me some direction? And they can give you direction. They can't give you legal advice, but they can give you procedural advice. And boy, do they know their procedure. They really do. You have 3 clerks who have over 30 years experience. Lori Rico is our senior clerk, and she's got well over 30 years of experience. Marlene Karp and James Felice. So you have a wealth of knowledge that's there. And we have about 7 people working for us, and we do about 700 to 800 new cases, new files each year, on top of the files that we have that continue. Conservatorships continue. Other matters continue. Trusts continue. So we have quite a few files in our vault. The court is often thought of as a people's court. Not everybody is represented when they come to the probate court. So you can attend a hearing and you can manage to work on files on your own. You're better off with legal counsel always, but you can manage things on your own. So don't be afraid to come to court on your own. The clerks will help you. If it's a matter that they really think you're well over your head, they're going to say to you, you really need to think about getting an attorney. Nobody will force you to do that because they try and help, but it is a people's court. Our goal is to be fair, kind, and compassionate, and we try and move matters. We try and move things expeditiously. Most matters can be moved fairly quickly. Some matters take a little bit of time. Trials and so forth, longer hearings take a little bit of time. But we move the court very efficiently. And we resolve matters, and hopefully we resolve them to most everyone's satisfaction. When you have a trial, not everybody is happy. There's usually one person who's not happy, but we try and give everybody their day in court and be fair and impartial. So, without further ado, let me introduce the panelists that we have tonight. They'll be talking about conservatorships, Title 19, and Medicaid. First is Attorney Renee Rosado, who's seated in the middle. Renee Rosado is a graduate of UConn Law. He has been practicing law for over 28 years. 25 of those years he's maintained a law practice here in town, in West Hartford. During that time he focused on probate law, primarily in conservatorships, guardianships, trust and estate administration. Attorney Rosado is also a probate trial lawyer, and he has worked in many of various probate courts throughout the state. Next, we have Attorney Jacqueline Reardon. Attorney Reardon is seated the farthest away from me. Attorney Reardon has been practicing law for over 25 years. She maintains her practice in Windsor, Connecticut. Attorney Reardon's areas of practice include Medicaid planning, elder law, trust and estate planning, including drafting of special needs trusts. She also focuses on conservatorships and guardianships. Attorney Reardon is a member of several professional organizations, including the National Academy of Elder Lawyers, and she is a certified Plan of Connecticut attorney for establishing and drafting supplemental needs trusts, which you may need on occasion. She also works in various probate courts throughout the state. Attorney Rebecca Hajosi is seated right here closest to me. Attorney Hajosi has been practicing law for over 21 years. She is an elder law attorney focusing on Medicaid, trusts, estate, and probate matters. Attorney Hajosi has offices in West Hartford and in Litchfield. She works in various probate courts throughout the state as well. She is the past chair of the West Hartford Senior Citizens Advisory Commission and the past president-elect of the Connecticut chapter of the National Academy of Elder Law Attorneys. Attorney Josie has also been a longtime professor at the University of Hartford. Very, very interesting. And she's taught probate practice and elder law there for over 11 years. So just how about a round of applause for the three speakers tonight. Thank you very much for your willingness to volunteer. I think before I let them begin, I just want you to understand that the lawyers who have volunteered their time are all very, very skilled, experienced lawyers. They're very good. By my estimation, I calculate their time preparing for their various talks and their time at each series. If you tally it up, it's probably about $100,000 worth of legal time. So we're very, very lucky to have all these wonderful attorneys volunteer to help impart their wisdom and really make for a great program. So I'm very excited about tonight, and I hope you are too. So without further ado, we'll hear from Attorney Rosado, and he's going to talk about conservatorships. Attorney Rosado.
Thanks, Your Honor. And thank you for coming out. I know it's pretty grisly out there earlier. What I'm going to talk about tonight there are four topics within conservatorships. The first is defining what a conservatorship means. I'm also going to talk about the probate court hearing process. I'm going to talk about oversight by the probate court when a conservator is in place, and also how conservatorships are terminated. So in terms of what it means to have a conservator, what a conservator is someone that's appointed by the probate court, and this is after the probate court has determined that a person is incapable of either making their financial decisions or incapable of making decisions that are related to their care. And in addition to a finding that a person is incapable through an involuntary process, it's possible for an individual to go to the probate court and make a request voluntarily to have a conservator appointed. And I'll talk a little bit more about that. There are two types of conservatorships. One is a conservator of estate, and that person would be responsible for managing financial issues. So that person would be responsible for managing assets, income, paying bills, making applications for different types of public benefits or other benefits. And then there's a conservator of person. A conservator of person is responsible for making personal decisions that are related to their care, making sure that a person has their basic needs met, whether that be food, shelter, clothing, safety issues, medical issues in terms of decisions that have to be made for treatment. A conservator of a person could be empowered to do that. Now, when you have conservatorships, you could have one or both of those appointed, and they could be, the court can tailor exactly what responsibilities are needed for that individual. There are several types of applications that are related to conservatorships. And the first type is a temporary conservatorship. These are not frequently filed, but they are filed in emergency situations. And when they're filed, the court has to find that if a conservator is not appointed, then a person could suffer irreparable harm. And these appointments are for a very short duration. They're for 30 days, and they could be extended for another 30 days by application to the court. But in no case do they exceed 60 days. There's also as I mentioned before, a voluntary representation. That's where a person is coming in and asking the court for the court to appoint the conservator. There's no finding of incapacity in that situation. And then the third and the most commonly filed application is an involuntary conservatorship. And whenever there's an application in the court, that application starts the entire process. So if a person is filing for a voluntary representation, also sometimes referred to as a voluntary conservatorship, they file the application. There's a court hearing that's scheduled. the individual needs to appear in front of the court, and within the application, it's defined what kind of assistance that person is seeking. So if that person wants a conservator to pay bills, for example, or manage a certain asset, they can specifically identify what they want the court to appoint a conservator for. And the court will review the application, and the court will frequently ask questions of the individual making the application, and if it's appropriate, the court will appoint a conservator. With involuntary conservatorships, there's a lot more involved. Involuntary conservatorships involve a situation where an application is made and someone's rights are being taken away. And the petitioner is the person that's the applicant, and the subject of the conservatorship, or the individual that that the application is for, is the respondent. And so before the hearing takes place, a number of things have to occur. The individual, the respondent, has to be served with the paperwork. And so they're served with the paperwork. Within that paperwork, there's notice of a hearing. And in addition to that, the court will appoint an attorney to represent the respondent. Because their rights are potentially going to be taken away, in Connecticut, the law provides that that person needs to be represented by counsel at one of these hearings. At the hearing, the judge is going to confirm that the individual is properly served. In addition to that, the court needs to make a finding that the application is filed in the proper district. So in West Hartford, for example, the court needs to find that the individual has either a residence in West Hartford or they are located in West Hartford. If a person is in a district where there's a hospital, but they don't live in that district, an application can be filed within that district, for example. When you have a conservatorship hearing, as I mentioned, the petitioner has the burden of proof to show that that person doesn't have the ability or lacks the capacity or is incapable of making certain decisions on their own behalf. And the evidence the burden is high. It's by clear and convincing evidence. The petitioner needs to comply with what's known as the rules of evidence. So the attorney representing the conservative or the respondent, if there's any objection by that attorney or if there's another attorney involved, the court would need to make a ruling to decide whether that kind of evidence is permitted or not. There's also requirements for a involuntary conservatorship for medical evidence. And there's a form that is filled out. In most cases, when an application is submitted, another document is submitted to the court, and that's known as a physician's evaluation. And the physician's evaluation is a standard form, and there are questions related to a person's capacity, their ability, their diagnosis, that are all within that document. And so a physician licensed in the state of Connecticut needs to fill that out, sign it, and it has to be sent to the probate court. And that petition has to be within a 45-day period of when the actual hearing takes place. The proceedings are also recorded during these conservatorships. And the way they work is that the petitioner presents their evidence first, so they would call witnesses and present evidence. This is followed by the respondent through his or her attorney presenting witnesses and evidence. And at the end, the court evaluates all the evidence that has been presented and makes a decision. And as I mentioned before, what the court has to find is that this person does not have the capacity to make decisions on their behalf. These decisions are subject to appeal. So if the court issues a decision, the decision can be appealed within 45 days. If the court appoints a conservator, it will define what those responsibilities are in the court decree, and it will also decide who is going to serve as conservator. The duties take into account the least restrictive amount of intervention. The goal of this, the statutes and the entire goal is to allow people to have as much independence as possible. So if the court makes a finding of incapacity, they want to try to tailor it so that whatever that individual needs help in, those are the areas that are focused on, and the areas that a person can function independently, those are untouched. All the rights that are not specifically assigned to a conservator are still held by the conserved person. In terms of how the court selects a conservator, frequently conservatorship applications are filed by family members, and within the application, a proposed conservator can be named within that. Also, there are documents that could be previously filled out that appoint or designate who a conservator of person and or estate might be. And so what the court does is the court will interview or canvass that individual to make sure that they have the ability to do it and that they're appropriate, an appropriate person. Part of this involves their knowledge of the individual, whether there's any kind of conflicts that they may have with the individual, and that they are going to promote the independence and the welfare of the individual. There are other things that the court will ask during that canvass, but the court will make an assessment of whether that person is appropriate to serve. Once a conservator is appointed, there's continuing oversight. And so with a conservator of a state, there are financial documents that need to be submitted to the court. These include an inventory. So an inventory is filed within 60 days of when a conservator is appointed. That document will include all of the assets and everything that that person owns, either personally or jointly, and that's submitted to the court. In addition to that, there's financial reporting that is periodically required to be sent to the court. Whenever any document is sent to the court, that document also has to be sent to the other parties and the attorneys in the case. And anyone can request a hearing if there's any questions about anything contained within the financial report. Or the court itself can schedule a hearing to review what's contained within the reports. The court also steps in when disputes arise. So the courts, if there's a disagreement between the conserved individual and the conservator or other parties that are involved, they could petition the court for a hearing, and the court would make a decision about that. There are certain things that require the court's permission and approval before a conservator can take certain actions. Among them, these aren't not all of them, but the major ones that the court is frequently dealing with is whether a person can be placed in an institution or for long-term care. So if that person is if the conservator is proposing to put that person in a skilled nursing facility, for example, they need to submit an application for the court and obtain that permission prior to that. To change a person's residence requires court permission. Terminating a person's tenancy or lease, selling household belongings. In addition to that, if a person owns real estate, selling, disposing, or selling, mortgaging, or transferring real estate will require prior probate court permission. There are other things as well, but those are the ones that I've seen most frequently. Additionally, the court requires periodic overviews, reviews of the conservatorship to determine whether there's a need for any kind of change or to continue the conservatorship. And the court will mandate this on a schedule. So when a conservator is appointed, a year out, there's a requirement for a review of the conservatorship, and then thereafter it's every 3 years. The conservator can be removed for failure to perform his or her duties. So the court reviews through these a number of ways. One, a conserved person can inform the court. Their attorney can inform the court that there are certain issues that the conservator or actions that the conservator is not doing, and the court could hold a hearing, and the court generally tries to address the problem without a removal, but if the conserved person does not have, if certain things are not being done, the court will certainly remove a person, a conservator, for that reason. Terminating a conservatorship is another area that I'm going to talk about. One, as I mentioned before, a voluntary conservatorship or voluntary representation, that person can send a letter into the court and giving the court notice that within 30 days they want their conservatorship to be terminated. And that the court will terminate it unless there is an involuntary application that's filed within that time. An involuntary application, the conserved person can make application to terminate the conservatorship at any time. So when that individual does that through their attorney or by themselves, the medical evidence is not required. They need to appear before the court, and the court, through whatever evidence that person provides, needs to be able to make a finding that the person is capable of managing certain things. For instance, financial affairs. If a conservator of estate is in place and the court determines that the person is capable of managing their own affairs, the court will terminate the conservator of estate, and the property that is owned by the conserved individual will be restored to him or her. Similarly, with a conservator of person, if the court determines that the individual is able to make their own personal decisions, the court will terminate the conservator of person. As I mentioned before, when the court has reviews, the reviews are done by the conservator. So the conservator of person will file a review on schedule with the court, and this is a form that asks certain questions, and at the end of the form, the question is whether the conservatorship should be continued, modified, or terminated. So if a conservator indicates that it should be terminated, it will trigger a court hearing. A physician's evaluation is periodically sent to the court, and when a physician's evaluation is sent, then the doctor can indicate whether there's a need to continue, modify, or terminate the conservatorship. Additionally, the attorney that is representing the conserved person will do the same thing. The court will require that the attorney meets with their client and report back to the court whether there's any need for a change, and potentially that could terminate a conservatorship. So why do we need conservatorships? When you look at, there are alternatives to having a conservatorship. A person can have a power of attorney. A person can have someone that's designated as their healthcare representative. When those prove to be inadequate, then frequently what happens is that there's an application for a conservatorship in the court. And at certain points in life, everyone needs assistance with decision making. And when you consider that children require parents or guardians to make decisions on their behalf, and parents are natural guardians, and so they make decisions for their children regarding health, regarding education, and other matters. When someone is not a parent, a natural guardian, then what and the court needs to, there's a need to appoint someone else, then that involves a court order to make that decision. And so similarly, when you're dealing with adult individuals that have intellectual disabilities, there's an application for a specific kind of guardianship in the probate court for that. And so that requires a court hearing and a court order and an oversight. Whenever an adult's rights are being compromised, or whenever certain decision-making is being taken away, in Connecticut, there's a hearing. There's a right to due process, and the court will ultimately make a decision whether a conservator, and what we're talking about today, is needed or not. This is a position of trust, and it's trust between a conserved person and a conservator, but it's also a public trust, because the courts are there to be able to respond not only to the applications, but to deal with these positions of trust. And the probate court, they monitor and verify whether these things are being done appropriately, and that's one of the purposes of the probate court, as Judge Eagan has mentioned. Thank you.
Thank you, Renee. It was excellent. Just by way of review, Renee talked about several things. There's an awful lot there that he has knowledge of. He talked about temporary conservators. Temporary conservators are appointed in emergency situations. It lasts for 30 days. It can only last for 60. It can be extended for another 30 days, but that's it. Attorney Rosado also talked about voluntary conservatorships and involuntary conservatorships. Voluntary conservatorships, he explained, the petitioner makes the petition to the court themselves, and they raise their hand and say, I need help, and I need help in certain areas. And he outlined, he said, you can say, I need help with my bill, paying my bills, or I need help with my medical, or whatever. And the court will appoint a conservator. There is no finding of incompetency there. No finding of incompetency. He talked about involuntary conservatorships, which are more there were more of those, as he explained. The involuntary conservatorships, you have to determine that the person has lost capacity. There has to be a due process hearing. He explained to you that you needed medical evidence or evidence indicating that that person can no longer handle their affairs. And there is a high standard there. We know clear and convincing evidence is a very high standard as lawyers. You may not understand that. You don't always know those different standards, but that's a very high standard. Why? Because we don't want to take away a person's liberty without making someone prove that they should lose their liberty. They should lose their right to manage their affairs. They might be doing things that we think are not right, but they're okay. They're painting their house pink, and we think that's crazy. Why would you paint your house pink? Because they have a right to do that. But they're giving away all their assets when they need their assets to care for themselves. That might be a reason that a husband or a wife goes in and applies for a conservatorship for their spouse. He talked about the hearing being recorded. The hearing is appealable. You can appeal directly to the Superior Court from a decision that's rendered by a probate judge in the probate court. And they listen to the hearing, and they use that hearing, and they render a decision like an appellate court would render a decision. So those matters are very, very serious. He talked about least restrictive means, that we try and leave people with as much dignity as possible. We try and take away as few rights as necessary and leave them with responsibilities that they can handle. And so they may be able to sign checks, and someone else is just helping them organize and write checks. You leave them with as much responsibility as possible because you don't want to take away a person's rights willy-nilly. Once appointed, a conservator has to file various things. He talked about many of the things that they have to file, but they have to file an inventory. They have to, if they're in charge of assets, they have to say, these are the assets I'm in control of. And they report to the court because the court is watching them. And then they have to file a periodic accounting. In West Hartford, we have the right as a judge, and any judge, I'm just going to say something just a little different than Attorney Rosado had said. It's usually by statute, the first year you have to file an accounting or a periodic report of what you've done with the assets, and a judge can make the determination that you file it every year thereafter or every 3 years thereafter. In West Hartford, in my court, I ask the conservators to file every year. I think it's easier to review. I want to keep close tabs on those files. I want to see what's happening to the person's assets that they're in control of, because they are an extension of the court. They've been given powers by this court, and they're reporting back to the court as to what they're doing with another person's assets. He talked about many things, so it was a heavy topic. Attorney Rosado, you did an excellent job. He talked about removal of conservators. Conservators can be removed if they're not doing their job or if they're doing something inappropriate. The conservatorship can be terminated in an involuntary situation when a person comes back in and demonstrates, I was incompetent or I wasn't able to handle my affairs. I'm now medicated, or I'm now doing something different, and I'm able to handle my affairs, and I would like control of my life back. And if they demonstrate, and they don't have to go to clear and convincing evidence, they just have to show by a preponderance of the evidence. Clear and convincing is like 75, 80%. Preponderance is like 51%. They have to demonstrate, I can handle my financial affairs. I don't want somebody else to handle my financial affairs. So please, court, give me back my control of my life. He also talked about powers of attorney. I won't get into that, but powers of attorney can be removed by the probate court when a conservator is appointed. They can terminate it, or they can suspend it. And so if they suspend it and the person is restored, then the power of attorney can kick back in, and it can be in existence. But excellent job, Attorney Rosato. Thank you very much. So I think Attorney Reardon is here to talk a little bit about Medicaid and Title 19. So hold your questions till everybody speaks, please. Thank you. I might not have said that at the beginning. I apologize. So we're going to hold the questions until everybody's had an opportunity to speak, and then we'll answer. We'll have a question and answer period. Thank you.
Okay, good evening, everybody. One of the reasons why sometimes a conservator is needed is to do a Medicaid application for somebody who's incapable of doing it themselves. Other reasons, of course, as Renee touched upon, but I'm going to be talking about Medicaid. Rebecca is too. I'm going to try to talk more about community-based Medicaid, but I will touch on Medicaid when someone's in a long-term care facility. Medicaid is a state and federal-run program that pays for health care for people who can't afford it. So whether you're in the community or whether you're going into the skilled nursing facility where the cost each month is very expensive, the average cost about $18,000 a month, so Medicaid applications will be done. I just want to do a quick contrast with Medicare, because I find in my practice people confuse the two. So Medicare is just a federally administered healthcare program that individuals must apply for within 3 months of turning 65. Medicare has Parts A and Parts B, so pays for doctor's visits or hospitalizations. There's a Part C, which is actually supplemental programs that you pay for, insurance to have more coverage that Medicare offers. And then Part D is for prescription drugs. All right, so that's Medicare. People will sometimes say, I'm going into a skilled nursing facility, Medicare will pay. It will not pay for custodial care, so long-term care in that skilled nursing facility, or for a program at home that I'm going to talk about, where individuals from the Connecticut home care program for elders will come in and render care. Medicare will not pay for that. Little caveat, if I break my hip, or I'm in the hospital and then aren't well enough to go home yet, need some rehab, and I go to a skilled nursing facility for rehab, Medicare will pay for up to 100 days. That's what they say, but they don't like to pay. So they might say after a week, okay, Jackie, your hip is all better, you've plateaued, leave. I can appeal that, but Medicare really doesn't want to pay for anything in a skilled nursing facility. So just keep that in mind. You do have some coverage, and sometimes it is good coverage. You know, I need 2 weeks, 3 weeks there to get my hip better or whatever I broke, so Medicare will cover. But they're very quick to say, you know, if I have dementia and, you know, my hip is broken, well, Jackie can't do anything in terms of physical therapy. She can't follow direction, so we're not going to pay. So then my conservator or power of attorney, if I've done good estate planning and don't need that conservator, will apply for Medicaid. All right? So Medicaid also has similar letters as Medicare. There's Medicaid Part A, which we don't hear too much about. That's for caregivers that are taking care of children and are below a certain percentage for poverty level. There is Medicaid Part B, which is for children. And by the way, I should say Medicaid in Connecticut is known as Husky. So you might hear Husky A, Husky B, Husky C, or Medicaid C. I want you to think of alphabet soup for Medicaid C. If you are aged, blind, or disabled, then you can qualify for Medicaid Part C. All right, so I can be 33 years old and have suffered some calamity, some awful accident, and now I am disabled. So if I meet certain criteria, I can apply for Medicaid to pay for my health care cost. So I'm living in the community, all right, I am disabled, I'm under 65, I can apply for Medicaid Part C if I meet certain criteria. All right, there's also Medicaid Part D. Think of that D for dollars. So if I am, not disabled, but my income isn't great, all right, so low income, low assets, then I can apply for Medicaid D to pay for my health care costs. All right. Going to swing back to Medicaid C a minute. I can be in the community and need Medicaid C, or in the skilled nursing facility, it's Medicaid Part C that you're applying for. All right, so that will take care of someone who is disabled, either living in the community or now in that skilled nursing facility. And I think, Rebecca, we'll leave it to you to talk about the assets and what you can have and can't have when you're in the skilled nursing facility, because it can be very strict. Individual can't have more than $1,600 in assets and be in a skilled nursing facility. If you're a married couple, you can have between $50,000 and $159,000, the community spouse. But the person in the skilled facility can never have more than $1,600 in assets. And I think people know that. They know that it's a program that the state wants to make sure that you don't have any other assets to pay. So that's Medicaid Part C. Now, if I am living in the community and I'm kind of in danger of going to a skilled nursing facility, but I'm not quite there yet, but I need some help, there's a wonderful program called the Connecticut Home Care Program for Elders. All right, so that's, again, administered here in the state of Connecticut. Several caveats. To apply for it, you have to be 65 years of age or older. I find that to be a hardship sometimes because, again, I have clients sometimes who might be 62, have Parkinson's disease, and need help with in-home care. They don't qualify for that program because they're not the right age. All right, so there's a program for people who are 65 years or older. So oftentimes, though, people will come to me and saying, my mom, my dad, my elder brother, is failing. They need some help. There's nobody really in the family who can do it, or the family member can't do it all the time. They're working, they have other commitments, so they can give some of the care, but it's draining. So is there a program that can help? And the answer is the Connecticut Home Care Program for Elders. Now, there's two components to this program. There's a Medicaid component, and then there is also state-funded. So state-funded isn't as harsh in terms of assets as the Medicaid component. So if I just need an aide to come in, maybe in the morning, to help get me up, shower me, prepare breakfast, maybe go do some shopping for me, take me outside for a walk, so 4 hours a day. So that would be the state funded, so not 24-hour care, something less than 24-hour care. I have to be, again, over the age of 65. I have to have certain needs that I need assistance with. So it can be bathing, dressing, feeding myself, toileting, transferring, any skill like that. Literally, a social worker will come out and do an assessment, see what skills that I need, what help I need, and then come up with a care plan. So if I am an individual and I need help with the caregiver under that circumstance, I can't have more than $47,000 in assets. So there is an asset limit. My house isn't counted as an asset. My car isn't counted as an asset. If I have a prepaid burial contract or a burial plot, not counted as an asset. And again, less than the $47,000 in assets. So then I would qualify. An agency would be chosen either by myself or, Connecticut Home Care Program for Elders can suggest 1 or 2 or 3. And then the caregiver comes and they are being paid for by the state. Caveat is that there's a 3% copay. So whatever the cost of my services are, I have to pay 3% of that. So again, think of the asset limit, and then there is that cost share payment that has to be paid. A married couple, so my spouse and I are, both in the home. Let's say that I have dementia. My spouse is doing an awful lot for me, but either needs a break or there's just some things that can't be done, needs assistance with, whatever. So again, I have the need. So if only one of us, myself with the dementia, needs the caregiver, we can have $63,000 in assets, so a little bit higher in terms of assets. And again, the house isn't counted as an asset, one car isn't counted as an asset, the prepaid burial or burial plot not counted as assets. So now caregivers are coming in the home, paying the copay or the cost share, and I'm receiving the care that I need. If now I take a turn for the worse and now I need substantially more care, 24-hour care, then I can apply for the Medicaid component of this program. Very harsh standards though. I can't have more than $1,600 in asset. And again, have to have one of those needs, or actually probably 2 to 3 of those needs, and then aides will come in. Aide can stay and live with me and take care of me. What I find in my practice is that sometimes it's difficult to only have $1,600 in asset and still have to worry about paying taxes, paying for my ability to live, food, etc. So that can be a challenge. So even though income, may or may not be important for certain programs, if you're applying for that Medicaid component of the Connecticut Home Care Program for Elders, if you have a high income, that's really good because you can't have more than the $1,600 in assets. All right, sometimes people are in their apartments, not living in a home, so they don't have to worry about the cost of taxes, homeowners insurance, etc. So then it's a little more palpable for people. But again, a great program, whether you need some help or a lot of help, but there are restrictions, and then there is the cost share component of that. All right. Now, I have dementia. I am at home getting the services, but now it's becoming just too much. Even if I'm able to afford the 24-hour caregiver, if I meet all of the components, if I now need the Hoyer lift to get out of bed, that's considered a 2-person assist, and the program might just not pay for that. Or if I just, don't otherwise qualify, and now I need to go to the skilled nursing home. Again, Rebecca's going to touch upon more than this, but I just want to say, because one of the biggest concerns that I hear from people is that, oh my goodness, my spouse needs to now go into long-term care, I'm going to lose the house. So there are, again, asset protections for the community spouse. Community spouse can keep the house, can keep the car, have a prepaid burial contract, and Medicaid, the government doesn't want to impoverish the community spouse, so you can keep some assets, and I had said that figure earlier, is between $50,000 and $157,000. which may or may not be a lot, depending on the lifestyle that people have had, what their savings have been, what the needs of the community spouse are. But the goal is not to impoverish the community spouse, certainly not to make them homeless. So that's one of the first things, I often hear when people call looking for an appointment is, that fear that the house will be lost to the spouse, or, mom needs the nursing home and now where's dad going to live? But again, always can keep the house, the car, the prepaid burial contract not counted as assets, and then some cash assets. All right. So I think I'll stop there, Rebecca, let you jump in and continue with the rest that you kind of developed in your handout.
Thank you very much, Jackie. So I'll be brief. That's a lot of information. It really takes an expertise in that area. But just to touch upon a couple of things, Jackie talked about Medicaid versus Medicare. I thought she did an excellent job describing the difference there. She also talked about Medicaid Part A, Part B, Part C, and Part D. She focused on the Connecticut Home Care Program for Elders, which was a state-funded program. Is that correct? And she did an excellent job developing that, and I know you're going to hear more from Rebecca Hajosi on that as well. She talked about when you need 24-hour assistance, you would move into the federal program in Medicaid, and there were qualifications that varied for both programs. And so it can be a very complex area. There are a lot of twists and turns, so it's good to have someone who has knowledge and can help you with understanding those twists and turns and what you can keep and what you can't keep. There is the spouse. I heard one attorney call it the spouse in the house that's left behind, and it's very important to protect that spouse as well. And I think Jackie did an excellent job talking about that. That spouse can keep the house, the car, prepaid burial account, and then between $50,000 and $157,000, depending on the circumstances. And I'm sure Attorney Hajosi is going to talk about other things and other ways to protect assets. So with that, I'll turn it over to Attorney Rebecca Hajosi. Thank you.
I wish I was talking about something that was a little more exciting, but I will do my best. So some of the things that I wanted to draw attention to that are more political are that I used to get everyone 24-hour care at home up until right before COVID. And the state was trying to structure their care so that the baby boomers, who we are hitting the peak of, and 2030 is the top of the bell curve for the baby boomers, there's not going to be enough nursing home space for the baby boomers at that point. So the government knew that that was coming, and so they started structuring these home care programs to provide the home care. Well, then there was a big push at the federal level to limit care and protect domestic employees. And they came out with a whole new series of laws regarding 5 hours of uninterrupted sleep, 15-minute breaks, and that really did end this 24-hour home care program that the state had been trying to structure for the baby boomers coming through. They are still trying to navigate that and figure out a way to get 24-hour care back in place, but it's hard to get 24-hour care in the home care program right now. Unfortunately, the government doesn't want it to be that way, but they're trying to navigate these labor laws to get that back in place before we start having a shortage of nursing home beds. And it's my hope that that comes back around. I see 24-hour care mostly for people that have dementia because they need queuing, less hands-on care, and but the big criteria for 24-hour care is sleeping through the night. I don't even sleep through the night. So I don't know. I used to ask my clients, oh, do you sleep through the night? And then I realized that I don't even sleep through the night. So that's a hard call. I love the home care program in Connecticut. It is one of the more robust ones from other states. So know that Connecticut is doing right by you and trying to do right by its elderly by helping people stay in the community. I focus my practice on helping people stay in the community. Right now, home health agencies, because of these domestic employee laws, they are now requiring 4-hour shifts, 2 days a week, $37 an hour. That's the kind of money that we're looking at. We are the second most expensive state in the country. Who do you think is the most expensive? California. Alaska. And that's just because, availability out there. But we also have a lot of good programs. So you are at home, you're getting care, you start running out of money. The state will always kind of be your backup plan, but is there a better way to structure things? Well, in the old days, and this, when I say old days, prior to 1993, you could give all your money to your kids, and then next month apply for Medicaid. And why would you want to do that? Medicaid has this asset limit, but it was a way to preserve your wealth. And, whether you're preserving it as a guaranteed inheritance or preserving it as a way to keep your spouse from being impoverished, there's motivations for doing that. But the government said, hey, wait a second, we don't like that. We are going to implement something called the 5-year look back. And in the old days, it was a 3-year look back. It's been 5 years for 22 years, I believe. And there's always the rumor that it's going to go to 7 years. That is never going to, I think, going to happen because the banking laws say that they only have to keep records for a certain amount of years, and we're butting up against that at the 7-year mark. So how does that work? Will you fill out an application that you're swearing is truthful? But that's not good enough. They want to look at 5 years of banking records. They are going to pull your 1099s. So they don't have authority to look at your tax returns, but they're going to ask for them a lot of the time, but not all the time. And so they're going to try to root out whether or not you're being truthful or not, and whether you transferred something out of your name for less than fair market value within 5 years. And if you did, they are going to penalize you and not let you get Medicaid for a period of time based on the amount of the asset transferred. So, yes, you could just go about and spend your money down paying for your care till you run out of money, and then go on a home care program or a program in a nursing home that will pay for your care. And a lot of people do that. And it's not a bad way to do things, but is there a better way? Yes. And so there has come out something called 5-year planning. And that is where you take an asset and you get it out of your name. So when you go to apply for Medicaid, you can honestly say, I don't own this asset. In its simplest form, you're taking something and giving it away. So if you had $100,000 sitting in your checking account, you could say, gosh, I trust my children. I'm going to have my children open up a bank account and put that $100,000 in there and sit on it. They're not going to touch it. And if I say that I need it, they're going to give it back. But it's not legally mine, and I have no legal authority over it, so it's not my asset for Medicaid. 5 years down the road, if I need to apply for Medicaid, that's not going to be an asset of mine. Things start getting a little more complicated if you want to kind of tie that money up to keep it, from your kids having immediate access to it, or more importantly, because of taxes. So most people don't have hundreds of thousands of dollars in liquid money sitting in accounts. They have 401ks, they have IRAs, they have brokerage accounts, and they have houses, which are usually someone's biggest asset. So if you transfer an account, a brokerage account, or a house, or any asset that has a low cost basis, which I'll explain in a second, to someone else during your lifetime, they take that asset at that cost basis. So if I purchased a house for $50,000 and now it's worth $300,000, and that is a very common scenario here in West Hartford, then if I give it to my children during lifetime with a cheap quitclaim deed that may cost you $500 to $1,000, then they take it at my $50,000. And if they sell the house, then they have to pay capital gains on the difference of the $50,000 and the amount of the sale. Capital gains on average is around 13%. So it sounds like a good idea to quitclaim your deed to your children. That is one way to get your house out of your name. You give it to your children and wait 5 years, but you're going to be hit with they are going to be hit with a huge capital gain on that when they go to sell it. So same thing with brokerage accounts. You have stock that's you bought it at $5, now it's Apple stock and it's worth $1,000. If you give that to your children during lifetime, they get that capital gain issue. If a person inherits an asset, unless it's an asset like a 401k or an IRA, it gets a step up in basis to date of death value. So your children can inherit, or whoever you're leaving it to, can inherit whatever the date of death value is. If they immediately sell the house after, or they cash in the brokerage accounts, there's no capital gain. So there is there's a very specialized trust called an irrevocable grantor trust, and it's designed for this very issue. It gets the asset out of your name for Medicaid purposes, but not out of your name for tax purposes. That way, if you sell your house during lifetime, you get your personal housing exclusion, so you don't pay capital gains. If you pass away owning the house or the brokerage account, your children or whoever is the beneficiary gets a step up in basis to date of death value, just like they would if they inherited the house. So that is a really common technique. It is the bread and butter of an elder law attorney's practice. I've been doing them for over 20 years. They are tried and true. So transferring an asset and waiting 5 years will always work. If you want to have a tax advantage, you would move it into a trust. When you do 5-year planning, you're doing planning to protect that asset should both spouses need Medicaid. If one spouse needs Medicaid, I can protect every cent for one spouse. What I do is I move all the assets to the wealth spouse, and then I do something with the assets to make that person look falsely impoverished. There might be huge tax consequences in doing that, but if one spouse gets ill, before you run off and spend all this money paying for care, go see someone that can help you map out a plan to protect those assets in a way that won't impoverish that spouse. But what happens if that spouse needs care themselves? Then they're going to have to spend down all their money because you're already on Medicaid or you've passed away, and now your spouse needs Medicaid. Then the assets aren't protected. So yes, a house is not considered an asset for eligibility purposes. But if you move out of that house because you need to go to a nursing home, all of a sudden you have this pot of money that is not protected. If you pass away and you've been on Medicaid and you own the house, the state of Connecticut is going to be a priority claim holder, and they're going to seek repayment for their care. So it's protected for eligibility purposes, but not for payback purposes. So 5-year planning takes assets, moves them out of your names so they're not yours for both of you, And emergency planning, which is what I call it, is planning for if one person needs Medicaid, we can protect the assets, but we're only protecting them for one person versus the both of you. Now, there's pros and cons to getting the assets out of your name. If you structure it correctly, you hopefully have a lot of flexibility in manipulating the assets. For instance, you make sure that your trustee of the trust understands that if you want to sell your house and move into a condo, that they would hopefully do that because you have no control. The control is with the trustee. If you decided to change gears and you wanted to sell and rent or go to a continuing care community or an assisted living and you're struggling financially, then your trustee, you have to go to them and say, I know I'm not a beneficiary of this, and I know you have no legal right to give me any money, but I would like you to give yourself some money and from your accounts, pay some of my bills to help me because I'm struggling or I'm changing gears. So whatever plan you decide to do, you have to 100% trust the people that you are bringing into your plan, and you want to make it flexible enough to ebb and flow with whatever actions you're going to take, because you don't know exactly what your future plan is going to look like. You don't know when a health event's going to roll out. You just don't know all those things, so you need to have that flexibility. I have a lot of clients that a trust is just a little too pricey for them because, trusts are complex legal documents and they cost a little bit. So some of my clients do something called a life use deed. A life use deed is where you bifurcate the deed of a house into two parts. One is the life use tenant and the other is the remainderman. So you basically give your house to another person with the retained ability to live in it for your lifetime. The reason why I do that if a trust doesn't seem appropriate is because it still gets you that step up in basis upon date of death. So it is another alternative to a trust. It has a few downsides. If you decide to sell your house during lifetime, then the part that went to your beneficiary doesn't get it has a capital gain issue. It doesn't qualify for that personal housing exclusion. And some of the money comes back to you. Now, I have a client right now, and her husband has Parkinson's, and they transferred some houses out of their names, and some of them they kept a life use because they were rental properties, and a life tenant is entitled to the income. They decided that they wanted out of the rental business, and just this week, they are selling one of them. Well, she's in her 60s, and I ran her life estate value, and she is getting 45% of the value of the house back. So they had made it 5 years, and so the house was protected, but because they sold the house, 45% of the money is coming back, and it's now an available asset when it's time for them to apply for Medicaid for him because of his Parkinson's. So when you're looking at coming up with a plan for yourself, first you want to say, can I make a 5-year plan? Or am I already into an emergency plan situation? And when do most people do 5-year planning? Late 60s, early 70s. Or you know that you have a degenerative health issue. You've got, you've got Alzheimer's, or you've got something that you know is going to get progressively worse. You want to start the planning now. Then you might not be able to protect a ton of stuff because it's all bumped in IRAs or something. Then you want to do your emergency planning right before you need Medicaid. And emergency planning is slightly complex, but what it boils down to is that Medicaid looks at income and they look at assets and they treat them very differently. So when you have a spouse that's in the community with you, there is a wonderful planning technique where you take your assets and turn them into an income stream. Because a spouse can have any amount of income and you can still qualify for Medicaid. So your spouse could be making $20,000 a month in income and you would still qualify for Medicaid. So we turn an asset into an income stream. Well, then the spouse is getting this income in every month and it's starting to put them over that $157,000 asset limit. Well, guess what? That asset limit is only in place during the eligibility process. If I am under $157,000 and then my spouse goes on Medicaid and the next month I win the lottery and I get $5 million, I get to keep my $5 million and he stays on Medicaid. So we take this money, we turn it from an asset into an income stream. Then that money starts pouring back to you, but we don't care because we've already gotten Medicaid granted and the money comes back into your pot. And yes, there's a little tax along the way, but it's still way, way, way better than having to lose all the money paying for care. So those types of plans, if you don't do a plan, you're going to be fine. You might be broke, but you're going to be fine and you're going to be taken care of. You can do some of this type of planning, and the level of planning depends on your whether you're married, where you are in your journey, what your family situation looks like, what your assets look like. But those are the main types of planning. Now, there's a couple of exceptions to the Medicaid rules. One is that if you have a disabled child, you can transfer any amount to that child at any time. There's downsides to that. What happens if your child is on Medicaid? You're not going to give them money because then it's just going to knock them off their benefits. So that has to be done with some care, but it's a good planning technique. Another real popular one is it's called transfer to caretaker child. If a child lives with you in your home for 2 years or longer and provides care to you, which has to be documented in some way, then you can transfer your house to that child without a penalty period. There's another one that's almost like that, but for anybody. You live in somebody else's house and or they're providing care for you in that house, then you can transfer money to them because now you don't have a house to transfer. You can transfer money to them if they provided that care for 2 years. There is I do a lot of around here in West Hartford. I have a parent build an in-law apartment on their child's home. That's an exempt transfer because it's for their benefit. So yeah, it might cost $125,000, $150,000, but it's going to benefit my children because it's going to increase the value of their house. So there are those types of transfers that you can do that would allow you to transfer money without just spending it down on your care. And also protecting your other assets. Something that's slightly newer that has been coming along is that you can have a child get paid by the state for taking care of you. And it's a tax-free stipend, and it's up to $3,700, depending on the level of care. But a lot of kids that move parents in are having the kids get paid from the state as an added little benefit. All right. Yeah.
I know you have a lot of information.
Yeah.
Thank you very much, Attorney Josie. That's an awful lot of information. She was kind enough, Attorney Josie was kind enough to provide us with, in the handout, and I hope everyone grabs a handout before they leave, Connecticut Medicaid 101. I won't even try and summarize everything she said. Very, very excellent job. I really appreciate all that information. And I just wanted to stop everybody from speaking, because I know some of the people in the audience have questions, and so we'll get an opportunity to hear from all the wonderful attorneys that are here. So I know there was a woman there in the white jacket that had a question. Do you want to just, and you have to speak up, and I'll try and repeat the question.
My question is about children with intellectual disabilities and the timing for applying for that conservatorship, whether there's a difference under 18, over 18, if the process or if the application is the same.
So your question is about children with disabilities and applying for Medicaid benefits?
No, conservatorships.
Oh, okay, and applying for a conservator?
Yes.
Okay, I'll ask Attorney Rosado.
So conservatorships are for adults, and so anyone under 18, you can't make an application for a conservator. For someone that has an intellectual disability, you can file before they turn 18. It's a short window, and Judge Eagan can correct me, I believe it's 90 days before the child turns 18. For an application for someone that has an intellectual disability, the criteria that the state uses is that that person has to have an IQ below 70. And so what happens is an application is made, and the Department of Developmental Disabilities, they file a report. It's called the team assessment, and they make recommendations. They review psychological evaluations and other material to determine whether a person is qualified or not. And so they file their report, and the petitioner, typically a parent, will submit an application, and they frequently supply the court with a psychological evaluation as well. And then the court reviews it, but this is statutory, so the court can't approve a guardianship of a person with intellectual disabilities unless they have an IQ below 70. And if a person has an IQ of 71, for example, then you'd be looking at a conservatorship. Is that one?
That's helpful.
Does that answer your question? So a person younger than 18 can have a guardianship. And the guardianship then can be converted into a conservatorship, and you can apply before the 18th birthday for the conservatorship, so you have it in place, so it's seamless, which makes sense. Okay. Any other questions? Yes.
When we were talking about Part A, B, C, and D, when you have a child with a disability that then becomes an adult, so goes over into 18, which part do they have? Because I understood that you said Part D was that they're not disabled but low income, low assets. So what would be an adult child with a disability under Husky?
So let me just see if I can summarize that again. So the question is an adult child with a disability, do they apply for Part A, B, C, or D?
Once they become, that they were under Husky before as a child, but now that they're an adult, which one would they fall into?
So Attorney Reardon will.
So it's going to depend on their circumstances. So if they're able to work, then it could be Medicaid Part C. They're disabled. All right, so they can work though, so they can apply. And if they're able to work, then there's a different category, also work and disabled, which is a great program in Connecticut. So it allows somebody to work, and if you're disabled and can work, you can have a retirement account and be able to keep more of your income. So think about that program if the person's able to work. If they're not able to work, and again, disabled, Medicaid C, and then if they have, low income, then it's Medicaid D.
So it sounds like this might hit.
Josie.
Yeah, it sounds like this might hit both of you. When your child turns 18, you determine whether or not you want to apply for SSI for them, or SSDI, but SSDI, you can't get, they won't be entitled to until one of you reaches retirement age, one of the parents reaches retirement age. So usually you apply for SSI, which means that you're not going to get the health care. You usually try to keep your kid on your health care for as long as possible, and then when they get, I think it's 26 now, you have to get them off your plan. And then usually at that point you're going to go on Husky C, because that they've been determined disabled and they're on SSI. But once they turn 18, you also want to be looking at other programs. You want to get them on DDS wait lists for their waivers. You want to get them on, if they're autistic, the autistic waiver wait list, so that then they can start getting help with like job coaching and occupational therapies and other job skills, just about social skills, and can get plugged into some group programs to help them become more independent. And those are all different Medicaid programs that are just available for different scenarios.
Thank you.
DDS.
Yes.
Yeah.
So if you're autistic.
Well, no, well, the DDS has an autistic waiver, an autism waiver program. Yeah, it's waitlisted. That's what I'm saying. You got to get on the wait list as soon as you can.
Thank you. We have another question.
Yeah, I heard if you have a private paid, like long-term care policy, there might be some impact on the spend down in Connecticut. So you might be able to avoid some of the spend down requirements. I'm not sure.
So the question is, what impact does long-term care insurance have on the spend down in Connecticut? Attorney Hajosi?
Well, if you have long-term care insurance, it covers a certain amount of your costs. So hopefully it staves off the need to apply for Medicaid, but it's not going to change any of your levels, your income limits or asset limits, unless you have something called a partnership policy. A partnership policy is a policy that says for every dollar we spend, that's a dollar you can keep in your bank account and still qualify for Medicaid. They are, I would say, the Cadillac of long-term care, but we don't see them very often any longer because they are so incredibly expensive. I mean, I know people that are paying $800, $900 a month to keep their partnership policies in place. So if you're lucky to have one and it's at a reasonable rate, it's great. But otherwise, long-term care is a good way to stave off Medicaid, and you, depending on what level you have, you can weather a storm. But how big of a storm? I see a lot of policies lately that they'll cover $300 a day, $700 a day in a nursing home. So you're still bleeding, is what I call it. Yeah.
Attorney Reardon, did you want to
No,
address? Okay.
that's just it, yeah. I mean, it's great if it's a way to pay for, and they can pay long-term care policies for home care services too. But we might have, all have this experience too, where sometimes they need a great nudge to start to pay, and then they pay a month behind too. So sometimes that's just something to keep in mind.
Thank you.
Any other questions? Yes, ma'am.
This is for Rebecca. I'm sorry, I'm missing the first name.
Yeah.
Remember your
Yeah.
You had spoken about the ability to quit claim deed your house to your kids, but then they would be hit with big capital gains taxes. And then you also talked about a trust right after that. Was that revocable or irrevocable?
Okay, wait a minute. So I'm going to repeat your question. You want to know about the quitclaim deed with the life use.
No, I don't want to know about that. It was right after that she said another alternative is to get a trust. And I didn't know if it was revocable or irrevocable.
So you want to know about the trust that Attorney Hajosi spoke about, and I'll let her address it.
Thank you.
I just want to make sure the audience knows what the question is, so I'm speaking up.
So it has to be irrevocable, which is why you have to say, okay, I'm basically giving up ownership of my house and giving it to another person. I see a lot of clients that come in and they think that they have protected the house by putting it in a revocable trust. A revocable trust avoids probate, but it doesn't protect your asset. I'm in my 50s, I have a revocable trust that my house is in so that my kids don't have to go through probate, but it's not going to, when I'm in my late 60s, I'm going to transfer it to an irrevocable trust so that I have that protection and make sure that my kids can get my house. when I pass away.
Okay, thank you, that
Yeah.
explains it, thank you.
Any other questions? Yes, ma'am.
Mine's related to Medicaid. So I have a parent who's on Medicaid. They did not do any planning before they applied. So I just want to understand the other valuable consideration, whether they can transfer money. Like if I were to go to their house and provide care, which I do, is that something that I would have to live with them in order to qualify? And then would that be like taxable income to me? I just want to understand how that might work.
So the question is, what can be done for a parent who is already on Medicaid?
Right.
And also, if I provide care for that parent, can I be paid for that care?
Right, because my father is not on Medicaid, but my mom is on Medicaid C. So again, that we kind of lost out, I think, on a lot of this pre-planning, but I'm just trying to understand maybe some buffers here to kind of protect him and some of that money for him.
So I think both Attorney Reardon and Attorney Josie. Attorney Reardon first.
So, already on Medicaid, a child can be paid, but not by, transferring the house if they're not living there and aren't meeting the criteria. But in your case where you're showing up at the house, you can be paid, but what you would really need is a caregiver agreement.
Okay.
So you need that all documented, that you're being paid, a certain wage, specifically what are the tasks that you're doing. So pre-pouring the medication, going to the pharmacy to pick up the medication, preparing meals, etc. But Medicaid scrutinizes those caregiver agreements, very closely.
I actually became a qualified caregiver through the state so that I was getting paid for a time through the state.
Okay.
But I mean, she's my mom, so I help
Yeah.
even when I'm not getting paid. But again, it's just trying to protect what they have before it's gone.
Right, yeah.
And I'll just ask Attorney Reardon, then if there is an agreement and the parents pay money to the caregiver has to report that.
As income, yes. To your second part of your question, yes, that's
Okay.
I wasn't
Did-
sure if that was different. And then like, if we were to build an in-law apartment at my house and have my parents move in, then potentially money, like if they sold their house, that money from the sale of the house could be used to fund the in-law apartment without penalty?
Yes, if spending down assets, the golden rule is that the money is being used for the person who will be applying for Medicaid, used for their care. So they just can't say, oh, my child needs a swimming pool at their house, so I'm going to sell my house and use that for that. But yes, okay, my child's going to welcome me into their home, they're going to build the in-law apartment, so that is something being spent for their care. So that is okay. That's, again, the standard, spend down, used for your care.
So Attorney Josie, the question again was if the parents sold their house and they used the money and the daughter uses the money to put an addition on her house to house the parents, is that legitimate?
So, well, first off, if your parents haven't taken the house from joint and moved it to just your father, they need to do that. And then your father needs to have a will that says that the wife's not getting anything, because we don't want him to pass away first. Then, if he sells that house, it's all going to be in his name, and she's going to stay on Medicaid, and we don't care that he's over the 157 asset limit. And then they could move in with you and start paying you. I call it a reimbursement agreement versus rent, so it's not income, but you have to limit it. And then they could put that in-law apartment on. And in that scenario, you don't have to, but I always like to see a contract so that it's very implied what's happening. And so then you can present that to Medicaid and they understand. And once again, all of that none of that's for your mom's Medicaid. She's already on Medicaid. This would be for if your dad needed Medicaid. And yes, if you provided 2 years of care to him in your home, then he could transfer a lump sum of money to you if it was well documented.
So,
That's helpful.
see one of these attorneys. Any other questions? Yes, ma'am.
What's the difference between a voluntary conservatorship for bill paying and that sort of thing, and just hiring an accountant?
So the question is, what's the difference between a voluntary conservatorship versus hiring an accountant? Attorney Rosado.
A voluntary conservatorship, you could specifically request the probate court to appoint a conservator. And as I said before, if you can terminate it at any time just by sending a letter to the court, and within 30 days it'll be terminated. Now, in terms of a conservatorship, that is a position of trust. It's a appointment by the court, and that person is responsible to the court. An accountant is someone that you are hiring privately, and that person does not have any accountability. So you could hire an accountant or a bookkeeper to pay your bills, but that person is doing that through employment versus through the probate courts. That person has accountability and responsibility that's monitored by the court, and they could be held accountable through the courts if they did anything improper.
So if a voluntary conservator is appointed when you are competent, you have to be competent to ask for a conservator, but they report to the court, as Attorney Rosado was saying. If you had a power of attorney or just a bookkeeper or an accountant helping you, they're helping you privately, and that can be an independent arrangement. It's not public, it's not something that the court would be overseeing.
Do you pay
Yes.
Do you pay for the conservatorship service?
Attorney Rosado.
Yes, if someone qualifies, the court will pay for the services of a conservator that's appointed. Otherwise, conservators are paid through the funds that the conserved person has. So it's through their own funds.
So if there are ample funds there in your account, conservator will take their fee. If there aren't any funds, most conservator will take the state rate, which is like $52 an hour, which isn't very much. But they will be paid by the state to manage your affairs.
Okay, basically, the benefit is the surveillance of the state over the service.
The benefit is to have the court overseeing what's going on so that no one is taking your funds or doing something that's inappropriate. But if you had somebody that you trusted, trusted family member or somebody that you felt they could handle that, that would be sufficient as well, and it would be private, and it doesn't have to be exposed to the public. Conservatorship hearings are public. People think they're private, they're public. Anybody could wander in and listen to what you had to say at a conservatorship hearing. Not all probate hearings are public, but conservatorship hearings are public. And you're subject to the terms and conditions of the statute and the court. And you have to report to the court. That's how the court keeps tabs on its conservators, to make sure that they're doing what's appropriate. So I think we have time for another question. Is there one more? Yes.
Is there any, not that I don't want to try to be paid, but I have several friends who are really older women who really just didn't plan well, don't have assets. Are there any kind of pro bono services for them to get basic, they don't have a lot of assets, but
Basic legal advice?
basic advice about like applying for Medicaid or in Title 19 and things like that, just so they don't make any like major missteps along with it. It's really about them getting the care, not so much about protecting the assets, because they really don't have to.
So the question is there a pro bono resource for individuals who need Medicaid and information of that sort? Is that correct?
Yeah, and then maybe a little quick follow-up to that would be, if somebody were going to pay the basic, say that we're going to hire one of you, and you're going to do a basic application for that, would that be the ballpark be for something like that?
Okay. I'll let Attorney Reardon begin in that.
I'm just confused by the first part of the question. You want them just to be able to get advice about applying for Medicaid, or?
Just even Title 19, you know, they just don't know what to do. They've got to the point, usually a medical thing takes them down, is what happens. And they own a house, sometimes they're not, or they're whatever, and they just find themselves in trouble. And they call, you know, they ask them, can you do? I'm like, I don't know, I don't really know where to send somebody. But if they have to pay for it, that's fine. So if there's a ballpark for like a simple, you know, like if you get a will done, if you get will, power of attorney, and it's usually like $800 to $1,000 for a simple, I'm just making this up, dollar fee, making that up. Is there just any kind of process, either pro bono or, you know, a package that somebody could actually get that they would know upfront what that might be?
Well, so if they're looking for legal advice and go to an attorney, I mean, all attorneys differ in what they charge. Some have the free initial consultation.
Right.
You know, some will charge, you know, substantially for that consultation. If, you know, if you were just asking, I thought your first part of your question was going to be about what services are available for someone. I mean, yes, town social workers
Okay.
are usually very good at saying,
Right,
you know,
okay.
you can apply for this, apply for this, apply to do that. And they might even help like with energy assistant applications or
Okay,
things like
that's very
that.
helpful. That's-
Yeah.
Like that, thank you.
Okay. Thank you.
Oh,
Attorney Hinojosa.
and the social workers will help you fill out the applications. But there are also non-attorneys that do applications, but, you know, their average fee is $7,000 to $9,000. To actually do the applications. There is a real great resource that started about 2 years ago. It's called the Elder Justice Hotline, and it's manned by attorneys. And you can Google it. I don't know the number off the top of my head, but it's through the AG's office.
Okay.
You tell them what your query is, and then they will point you to the right people to help. It is always so complex that there's not one place where you can get everything all in one.
No, but thank you, those are two awesome.
Yeah.
Great. Anyone else? All right.
Thank you.
Well, I just want to say thank you all for coming out and braving this storm. I wish you all happy holidays. These sessions or series were recorded by Channel 5, so you can see them on Channel 5 or on YouTube. If you need to pick up any of the handouts from any of the series, you can call the probate court, and the clerks will have them there. If not, they'll run another copy for you. So I really appreciate everyone's attendance today, and thank you for your wonderful questions. I want to thank the attorneys that gave up their time, their valuable time. They did a great job. I just ask if you'd give them a round of applause. Thank you very much. Thank you all. Have a good crew here. All right. Have a nice night. Thank you.